So my name is Allyn Ayers, and I'm an attorney and the LegalARTLink director at Locust Projects. And again, I apologize in advance for any technical difficulties that might come up. I'm still getting familiar with the Zoom platform. All right, so due to time constraints, I'm not going to be taking live questions during the presentation. There is a chat function on Zoom. I'm not sure if I'm going to be able to see the chats while I am sharing the screen, but I will review the chats at the end of the presentation. So if you have any questions that come up while we're going, you can go ahead and enter those into the chat. 1 second. Oops. I'm trying to find out how to minimize the screen on this side. All right, there we go. Okay. All right, so today I'll be covering some legal issues related to COVID-19, but I also want to be clear about what I will not be covering. I won't be covering certain resources that are available to artists and creative professionals, like emergency funds and grants, or platforms for you to share your work during this time. You can find that information on the Locust Projects webpage. We have an aggregation of that information, and there are a lot of other websites and resources that have pulled together this information, but I'm going to be focusing on certain legal issues today. I'm also sure I won't be able to cover all of the legal topics that are relevant to you or that you may have encountered thus far. So if you have something specific that you'd like to discuss, you can put that into the chat if we have time, or you can always contact me after the webinar as well. I'm just going to start with a little bit of information about the LegalARTLink program in case you're unfamiliar. So LegalARTLink is a program provided under the umbrella of Locust Project's other offerings that aims to empower artists by providing legal information and advice for specific issues, as well as educating artists and empowering them to take control of their careers by providing general information about law as it relates to arts. Normally, we offer legal assistance to members of Locust Projects. There is an annual membership fee. However, in order to support the community during this public health and economic crisis, we're currently waiving that membership fee for access to LegalARTLink for 3 months. So if you're not a current Locust Projects member, you can still submit your LegalARTLink question, and you don't have to become a member or pay that membership fee at this time. So please, if there's something specific that you would like to discuss with me, please don't hesitate to visit our website. It's locustprojects.org, and you can navigate to the LegalARTLink page where you can submit your issue online. If you can also email me at my email address, which is shown here, legallink@locustprojects.org. The final point of housekeeping before we get into the substance, because this is a legal presentation, it does come with a disclaimer. So here it is. The materials and information provided during this webinar are for informational purposes only. They are not intended to provide a legal opinion or constitute legal advice, which must be tailored to the facts of a particular situation. Due to the novelty of this situation and the rapid changes to public health policy at the local, state, and national levels, the information provided during this webinar may not contain the most up-to-date legal or other information. Use of and access to this webinar does not create an attorney-client relationship between you and the provider. You should consult an attorney for legal advice relating to any particular issue or problem. By way of an additional disclaimer, I'm also including a lot of information that is tailored to what's going on in Miami-Dade County. But if there's anyone who's joining us from a different county, I'm happy to help you find your county-specific information after the webinar. All right, so here are the topics that we're going to be addressing today. I tried to pick the topics that would have the most relevance to the most people, but like I said, I know there's going to be things that may have come up for you already that I'm not going to address. But I'm happy to take those questions or speak with you individually outside of this webinar. First, we'll be looking at the law around what are your obligations and rights regarding your current projects. So I'm hoping to give you some information and tools to help you methodically go through the work you have lined up for the next few months and to help make arrangements if necessary. Next, we'll go over some cash flow options, including the new legislation regarding student loan payments and how evictions are being handled. We'll also look into the new legislation that was passed last week called the CARES Act, and specifically at two provisions that are likely to help with the economic burden resulting from the loss of work, namely direct payments to individuals and the expansion of unemployment benefits. And again, I'll try to answer questions at the end, but if anything comes up while we're going, feel free to type it into the chat function so you don't forget your question. All right, so we'll go ahead and get started with current projects. First, I'll be going over some concepts related to your current projects and agreements and hopefully help you strategize and manage those obligations. As we go through these concepts, I encourage you to think about the contracts and projects that you have lined up and consider whether these concepts apply to the obligations that you owe or to the obligations that are owed to you. Keep in mind that you might fall on either side of an issue. You might be the party who is owed something. The other side is not able to provide because of a COVID-19 reason, or you might not be able to provide what you owe in the agreement because of a COVID-19 reason. So first, I'm going to go over some technical contract law concepts. And I just want to point out that the term contract here doesn't necessarily require a formal written agreement between parties, though a written agreement is always helpful and we generally encourage you to have one. You can, though, have a legally enforceable agreement in an informal writing, like a text message or an email, or even a verbal agreement, though those are more difficult to prove if you get into a dispute over that agreement. If you do have a written agreement, start by looking at the termination clause to see if you or the party that you're contracting with has a right to get out of the agreement if you're not able to perform, and any steps regarding notice you might need to take to do so. Generally speaking, when there's a large unforeseen event that prevents parties from completing their obligations under a contract, there are three legal concepts that come into play. You may have heard some of these. There's been a lot of articles and news about these recently, but the first one is called force majeure. We also have impossibility and frustration of purpose. So going to the first one, force majeure, it comes from the French term superior force and refers to extreme conditions beyond the contracting party's control. In contracts, a force majeure clause excuses parties from performing and sometimes allows the termination of contracts where certain unforeseen events happen. Usually these clauses are easy to spot in written contracts because they will name several types of events that can cause non-performance and typically include the term act of God. So if you look into your contracts and you see a term that says act of God, chances are it is a force majeure clause. The clause may also have conditions that need to be met in order to invoke force majeure, like giving proper notice of your anticipated non-performance to the other party. Whether or not force majeure applies to any of your agreements and how you can take advantage of it depends on the specific language of your written contract. So oftentimes these clauses will list several types of events that are considered force majeure under that contract. And whether or not the current pandemic that we're in falls under that clause will depend on the specific language in the contract. So for some people, force majeure will cover the current climate that we're in. For other contracts, it will not. So it really depends on the language in your contracts, whether you or your contracting party will be able to take advantage of this concept. It also matters when you entered into the agreement, because a big part of this is whether or not it was unforeseen. If COVID-19 was already a concern at the time you entered into the contract, then you might not be able to claim that it was an unforeseen circumstance. For example, at the end of February, beginning of March, there were already talks about possibly shutting down businesses or having some quarantines. So if you entered into an agreement after that point, it might not qualify as a force majeure here. If force majeure does not apply, or if your contract does not have a force majeure clause, or if you don't have a written contract, because you do need a specific force majeure clause. So if you're operating on an informal contract or a verbal agreement, then you won't have a force majeure clause. But there are these other doctrines that might excuse performance. Impossibility and frustration of purpose are similar in that they both refer to unforeseen events preventing performance of contractual obligations altogether. They both refer to unforeseen events preventing performance or that make it unreasonably burdensome to perform. Impossibility happens when unforeseen circumstances make the contractual duties impossible to perform. So for example here, if you booked a 250-seat theater for a performance a year ago, and an emergency executive order prohibits gatherings of more than 10 people and closes the theater as a non-essential business, then it would be impossible for the theater to fulfill its obligation to provide the space. Frustration of purpose is related, but it's slightly different. Under frustration of purpose, the obligations could conceivably still be performed, so you could still, in theory, complete the obligations of the contract, but the purpose of the agreement no longer exists or has been changed dramatically because of this unforeseen event. So an example here would be if you were hired to create a work for, say, a wedding or a large event that is no longer happening, you could conceivably still create and deliver that work, but the purpose of creating it, the event or the wedding, has been frustrated, and so the purpose of the agreement no longer exists. The key to availing yourself of any of these events is that it must have been unforeseen. So again, it's hard to predict how courts, like when exactly this delineation of foreseeability versus unforeseeability will come out. But if your agreements were made prior to December 2019 or January 2020, so before this was generally seen and feared to be a worldwide pandemic, it's more likely that a court would find it not to be, or find it to not be a foreseeable event. Then if, say, for example, you made your agreement in late February and definitely into early March when we were already starting to get shutdown orders. So that's a brief overview of the law, but as a practical matter, these are defenses against a breach of contract claim. So in practice, the way that these would come up is if somebody sues you or you sue somebody for breach of contract, and they're claiming these as a defense against that breach. So we want to get ahead of that. So I've come up with some recommendations on what you should do now to evaluate and prepare yourself for the obligations that you have on your table. So first, I'd recommend creating a list of all your current projects and agreements through the summer. Consider work that you have agreed to do. Also consider commercial leases for studio space, agreements that you have in place with vendors, suppliers, however informal they may be, assistants, employees, and any other relationships that you have with other individuals providing you goods or services. Determine your obligations and the obligations that are owed to you under these agreements and whether or not you will be able to fulfill them. If you have a written contract, look for termination and force majeure provisions to see if they apply, see if the parameters of those termination or force majeure provisions can apply to this situation and any conditions that you need to meet in order to take advantage of those. Consider whether performance of your obligations under the contract have been rendered impossible or if the purpose of the agreement has been frustrated. And then communicate with the other party, including complying with any notice requirements in your written contract. But generally speaking, it's better to get ahead of these non-performance issues than to be chasing it on the back end. You can generally avoid future conflict by communicating problems with the other side and coming up with solutions. This won't be true for every circumstance, but these times are especially difficult for everyone, more so than I would say other circumstances where you might not be able to perform. Everybody is feeling the burden of this COVID-19 pandemic. So it's more likely that there may be some room for negotiation and compromise, particularly with this situation. And of course, if you need any help along the way with these steps, please don't hesitate to reach out to LegalARTLink. We're happy to help you go over your contracts that exist to see if you have a termination clause that would apply, to see if force majeure applies, and to help you understand what you have agreed to do and how to manage that. I'm gonna exit out of the screen share just for a second so I can check if there's, yeah, so, okay, I was just checking the chat box. So after every section, I'll go ahead and exit out of the presentation just to check the chat. So if anyone has questions as we're going, you can enter your questions into the chat function and I'll check that at the end of each section. So I'll just wait a few seconds to see if anyone had questions about the contracts. All right, I think we're good. So I'll go back into the presentation now. All right, so that it should cover your current projects and contracts. So next we're going to be looking at cash flow. And the purpose of this section is to give you information to help you prioritize and manage your resources. Just to be clear, I'm not advising you to not pay or pay anything. So please don't go to your landlord later and say that LegalARTLink told you that you didn't have to pay your rent. Rather, I'm letting you know about the risks involved and the procedures that are available to you. Unless otherwise noted here, you are still responsible for paying what you owe, and late fees and interest may apply. I'll be going over several line items for you to consider to help decide how to prioritize your expenditures. You have student loans, federal income taxes, utilities, credit card debt specifically, and rent and mortgage payments. So first we have student loans. And I'm including this because many artists carry student loan balances and make payments for many, many years after they've left school. So I'm including this information with the thought that many of you are still making payments on your federal or on your student loans. This information does only apply to student loans that are held by the federal government, but it excludes older loans, specifically Perkins loan and commercially held federal family educational loans. So if you have one of those loans, then this does not apply to those. Those would be older loans. So these will be federal student loans that are still held and serviced federally. If you have private loans, you should check directly with your servicer. Many loan servicers, I was just looking at all of a lot of banks that offer student loans. They don't have specific policies posted on their website, but they are advising their customers to contact the customer service departments if you're experiencing financial hardship. And it looks like they're working with people on a case-by-case basis. So there might be some relief, although they don't have a policy that's listed on the website. Okay, so first I'm going to talk about interest. So on March 13th, President Trump announced that interest would be waived on all federally held student loans for at least 60 days. Then the CARES Act, which became law last week, extended that until September 30th of this year. On March 20th, President Trump announced that borrowers would be able to suspend payments for 60 days. Under the Department of Education's guidelines, borrowers had to apply for this forbearance. So you might have heard that you might have seen articles about Betsy DeVos requiring that borrowers apply in order to stop their loan payments. The CARES Act, which again passed last week, made this forbearance automatic and extended it through September 30th. So as passed in the CARES Act, you now do not need to apply in order to get that administrative forbearance. You should not have to take any action to pause your student loan payments, but I do advise checking with your loan servicer to make sure that the payments were stopped and that that they're not requiring you to take any action. I did check with my loan servicer, Great Lakes, and they had a COVID-19 resource that was linked on their front page, and it had this information on it. So I would recommend just giving that a double check if you have student loan payments. And finally, the CARES Act suspended collection efforts through September 30th. So if you have loans that are defaulted and they're in collection, they're suspending those efforts through September 30th per the CARES Act. Future acts may extend this date. All right, so what does this mean for your cash flow? If you have federally held student loans, your payments should automatically be suspended and your balance should not change at all because no interest is accruing through September 30th. Again, your loan servicer may have, or you should consider contacting your loan servicer for details and to confirm that they will automatically suspend these payments. As of yesterday, the information at studentaid.gov had not been updated to reflect the changes made by the CARES Act. So again, the situation is very fluid. Things are happening very quickly, and not all of the resources that are out there are always up to date. If you are on an income-driven repayment plan, so that's, for example, income-based repayment or pay-as-you-earn, you can also apply to have your monthly payment recalculated as a result from loss of income, though you will have to update your income after the emergency situation when it goes up. This may not be as necessary now that the forbearance is automatic. However, if you anticipate your income being lower after September 30th than it was prior to this month, I would recommend still applying for that recalculation, because once the forbearance is over, you would have a lower monthly payment. And you can apply at studentaid.gov. Again, this is only if you're on an income-driven repayment plan. I will say also, if for anyone who may be making loan payments towards public service loan forgiveness, there is an added benefit through the CARES Act that the forbearance period, so essentially the 6 months that last through September 30th, those 6 months of payment of $0 are going to count towards the 120 payments needed for the loan forgiveness. So if you are on the the PSLF program, or you plan to apply for that forgiveness, you don't have to make, or these 6 months of $0 will still count towards that. Okay, next we're going to talk about federal income taxes. Many artists work as independent contractors or are self-employed for tax purposes and end up owing taxes rather than receiving a refund. So that's why I'm going over this in the cash flow section. If that typically applies to you and you haven't yet filed your taxes for the 2019 tax year, the IRS has extended the deadline for filing and payment through July 15th, 2020. If the emergency conditions continue into the summer, they may further extend that deadline. So again, the situation is very fluid, but it's likely that if the economic emergency continues for the next few months, this deadline might be pushed back even further. You can file your taxes at any point. So you can file them and then wait to pay until up to July 15th. So if you have all that information already and you haven't filed it yet, you can go ahead and file them, but you won't have to, your payment won't be due until July 15th. You will still owe the taxes, but there is no penalty or additional interest for filing after April 15th, the way there would normally be if we had kept that April 15th deadline in place. If you do expect a refund, however, I'd recommend filing sooner rather than later so that that'll help you get some money a little bit more quickly by the refund. Finally, if you have already filed and submitted payment, but it hasn't been deposited yet, or you've set the payment to be scheduled for a later date, you can call this number listed here at the IRS to cancel the payment. And I have read some reports and testimonials of people who have been able to successfully cancel their payments. So again, their taxes are filed, but that payment is not due until July 15th. They had it scheduled, they canceled it, and now they will reschedule it for some point before July 15th. Next, we have utilities. Many utilities providers have committed to providing their services, even if their customers are late with payments, and in some cases are waiving late payment fees. So again, these are mostly tailored to Miami, but I'm happy to help look up other county-specific information if we have anyone joining from outside of Miami-Dade. So Miami-Dade Water and Sewer is suspending disconnections of water service for non-payment through at least April 20th. That was the date I saw yesterday or the day before. Again, if these emergency conditions continue, you can expect to see that date be pushed further out. FPL is suspending disconnections, providing payment extensions and waiving certain late payment fees while Florida is under a state of emergency. So if you anticipate not being able to make your FPL payment, it might be worth looking into what extensions and late fee waivers are available to you. Also, internet providers, more than 650 companies have signed on to the Federal Communications Commission's Keep Americans Connected initiative, through which they have agreed not to terminate residential or small business customers for non-payment, to waive late fees, and to open their public Wi-Fi hotspots during the pandemic. So you can check with your internet service provider on their website, or also the FCC has a list of all the providers that have signed on to this pledge. Many credit card companies, similar to the private student loans, have posted that they're offering to work with their customers who are facing financial hardship, but are handling requests on a case-by-case basis. And so they're not providing public information about universal relief plans. If you're short on cash and have significant monthly credit card payments, consider contacting your credit card issuer to see what options are available to you. Again, they're stating that they're working with customers, but there's not really any transparency as to what that means at this time. Finally, rent and mortgage payments. So as of earlier this afternoon when I was finalizing this presentation, there was no statewide moratorium on evictions, although there is pressure on Governor DeSantis to enact one. There is a federal moratorium on evictions from federally subsidized housing and from homes under a mortgage backed by the federal government. Locally, the Miami-Dade Police Department has halted all eviction activities until further notice. In addition, the Florida Supreme Court has issued an order that suspends the requirement for clerks of the court to issue a writ of position forthwith through April 17th, 2020. Again, these dates may be pushed out as these emergency conditions continue. And that writ of possession is the final document that's needed to evict someone. So to be clear, you are still responsible for your rent and you will still owe it to your landlord at some point. However, if you are not able to pay your rent and you do not pay your rent, the most that your landlord can do at this point is give you notice of your failure to pay, demand payment, and initiate the eviction proceedings against you. However, they can't get that writ of possession, and the Miami Police Department is not enforcing evictions. So you cannot be evicted for failure to pay rent at this time. If you cannot afford to pay your rent due to COVID-19, you may want to consider contacting your landlord about negotiating a payment plan or partial payment, especially if you expect a future influx of cash from the CARES Act provisions that I'll be going over next. I'd also advise that you consider your lease end date. If it's approaching, if it's coming up in the next month or two, and you anticipate your lease ending while we're still under a state of emergency, consider whether you might negotiate with your landlord a month-to-month lease if you don't want to renew for a new term. Okay, so that's the end of that section. So I am going to check the chat quickly. All right, looks good. So we will go on to the CARES Act provisions. Okay, so we'll next go on to the recovery rebate that's provided in the CARES Act. As I'm sure you're aware, the CARES Act, which stands for the Coronavirus Aid, Relief, and Economic Security Act, was passed and signed into law on March 27th, 2020. Today we'll be going over direct payments and unemployment, but there are a lot of other provisions in this act that might be useful to you. I've already gone over the student loan provisions, but there are also expansions of small business loans, which are available to self-employed and independent contractors and sole proprietors. So I'm not going over those today because they're still developing the guidance on how to apply for those, but we might do another webinar or issue some further guidance as those programs become more clear. But there are small business loans that are available to independent contractors, sole proprietors, which many artists work as. Okay, but we'll start with the recovery rebate. So Section 2201 of the CARES Act provides for a one-time tax-exempt payment to many Americans. The Act calls it a recovery rebate, so that's the term that I'm using here, but you have likely heard it referred to in the media as a direct payment or a stimulus check or many other terms, but when you hear those, it's the same thing as recovery rebate. So the full amount is $1,200 for individuals, $2,400 for married couples filing jointly, plus $500 per qualifying child age 16 or under. That full amount is subject to maximum income thresholds of $75,000 for individuals, $112,500 for heads of households, and $150,000 for married couples filing jointly. For every $100 earned over that threshold, the amount of the payment is reduced by $5, phasing out at $99,000 for individuals, $136,500 for heads of household, and $198,000 for married couples filing jointly. So for example, if you made $75,100, your stimulus check would be $1,195, and so on for every $100 after that. Certain groups are not eligible for the rebate, and those include non-resident alien individuals, those without social security numbers, dependents 17 and older. So again, that qualifying child caps out at age, so dependents who are 17 and older. So oftentimes this is older Americans who are living with their families, or adult children living at home. Won't receive a rebate, and also are not eligible for that qualifying child amount either. To determine, if you have not filed taxes for either 2018 or 2019, the IRS also might not have the information it needs to send your payment. So if you're late on the 2018 taxes, you may want to consider filing those in order to take advantage of this rebate. To determine whether you qualify, the IRS is going to be looking at your adjusted gross income from your 2019 tax filings. If you haven't filed your taxes for 2019 yet, again, you do have until July 15th to do so. They will look at your 2018 tax filings. If you are not required to file taxes, certain low income or recipients of Social Security, for example, you will have, or the IRS will be posting a simple tax return in order to receive the recovery rebate. Payments and timing. Okay, so timing. The CARES Act instructs the Secretary of Treasury to make the payments as rapidly as possible. The Treasury Department and the IRS have stated that they will begin distributions in the next 3 weeks. If you received a tax refund by direct deposit, the IRS will deposit the recovery rebate into the same account with no action required. If, however, like we said earlier, many artists are filing as self-employed or sole proprietors and end up owing taxes rather than receiving a rebate. So if that applies to you, or if you received a refund by another method, the IRS has stated that it will develop a web-based portal for you to provide your banking information. So it does not exist at this time, but soon, in the coming, hopefully, days or weeks, there should be a website for you to be able to securely put in your bank information in order to receive that direct deposit. Within 15 days of the disbursement, you will receive a notice by mail, the method of payment, the amount of payment, and a phone number to report failure to receive the payment. So if they end up mailing you a check and you don't receive the check in the mail and you get this notice, you can report that to the IRS by the phone number that they will provide. All updates will be available at this website, which I recommend checking frequently due to the fact that many of us will be needing to put in that direct deposit information. I was notified of the chat. Okay, so let's see. Okay, I will get to that later. Okay, so yeah, I do recommend checking this website frequently, because the sooner that you put in that the direct deposit website is available, you'll be able to input that information, and hopefully that'll happen before they're ready to disperse the payment, so you can be paid as quickly as possible. There have been reports of attempted scams, so be wary of those. The IRS will not be calling you for your bank information, so be sure that you're only providing it through this secure website that the IRS is setting up. Unfortunately, a lot of times during tax season, there's always phone scams with people claiming to be the IRS, and we anticipate them for this as well. All right, so that sums it up for the direct payments. In terms of unemployment, we'll be looking at the expansion that the CARES Act provided. Before we get to the changes that the CARES Act implemented, I'm going to go over the existing unemployment benefit system currently in place in Florida. As a general matter, Florida is not generous with its unemployment benefits, and Florida is among the lowest in the country for those benefits. Florida provides the 5th lowest maximum weekly benefit, so the maximum payment that you can receive is 45th out of 50 of the United States, and also the least amount of weeks of benefits. It's tied with North Carolina for the least amount of weeks that they provide. But generally speaking, this is how unemployment works in Florida. Some items here appear in strike-through because they've been temporarily waived due to COVID-19 through May 2nd. Maximum benefits are capped at $275 per week for 12 weeks. And that number is tied to the state unemployment rate, so it may increase if the unemployment rate increases significantly. To receive benefits, you must be able, available, and actively seeking work. Again, actively seeking work is temporarily suspended due to COVID-19 and the unavailability of work. You must have lost your job through no fault of your own, so you can't have quit or been fired for cause generally, and you must meet certain monetary earning requirements. Generally speaking, you are supposed to register for work registration with Employee Florida and actively search for work, but again, this requirement has been suspended for the time being. You also have to fulfill monetary eligibility requirements to determine whether you have that eligibility. You have to figure out what your base period is, and that's going to be the first 4 of the previous 5 calendar quarters. So I feel like that's best illustrated by example. So if you apply on in January of 2020, that's Q1 of 2020, then your base period would be the first 4 of the previous 5. So that's Q4 2018 through Q3 of 2019. You must have made at least $3,400 during the base period, and wages in at least 2 quarters of the base period. So you had to have earned wages during at least 2 of those quarters. And the total base period wages has to be at least 1.5 times the wages in the highest earning quarter. So you can't have all of your income loaded into 1 quarter. The benefit amount and duration. So the weekly benefit amount. There's a minimum of $32 per week and a maximum of $270 per week. To calculate your amount, you use the calendar quarter in the base period with the highest wages and divide that by 26. If it's less than 32, it'll be 32. If it's higher than 275, yours will be 275. The total benefit amount. So the total you can receive is the lesser of your base period wages divided by 4. So everything you made in those 4 quarters divided by 4 and 300 or 3,300. Benefit duration. The maximum benefit duration equals your total benefit amount divided by your weekly benefit amount. And again, the maximum currently is 12 weeks. Okay, so the CARES Act expanded the unemployment benefits that are available. And there's sort of two categories of people here: those who would normally qualify under Florida unemployment and those who won't. So first I'll go over those who would qualify under everything that we just said because it's a little bit simpler. So if you would otherwise qualify under the previous 3 slides, you would receive on top of that between $32 and $275 per week, an additional $600 per week, even if this brings unemployment benefits above your weekly wages prior to the COVID-19 situation. You also will get 13 weeks of additional benefits after you've exhausted the state benefits. So again, that's after the 12 weeks of the Florida unemployment plus 600, you'll get an additional 13 weeks of $600 per week. If you are already receiving or have submitted a claim, you do not need to do anything more to receive the additional benefits of the CARE Act. Okay, so now going on to those who wouldn't otherwise qualify under Florida's unemployment system. So the CARES Act created a program called Pandemic Unemployment Assistance, which applies to individuals who are not otherwise eligible for or who have exhausted their state unemployment benefits and who are unemployed, partially unemployed, or unable to work because of a COVID-19 reason. The Act lists a lot of, or it has a list of COVID-19 reasons, but they're very expansive, and they include things like not being able to work because of a stay-at-home order, or because your workplace is closed as a non-essential business, because you're in a quarantine, because you're caring for sick individuals, because you're exhibiting symptoms, because you're caring, because you are caring for the breadwinner of your family. It really expands the types of reasons for not being able to work. It also, unlike many states' unemployment programs, the Pandemic Unemployment Assistance Program is available to independent contractors, self-employed individuals, and so-called gig workers like Uber drivers. It does not cover workers who are able to telework and receive pay, or who are receiving paid sick leave or other paid leave. If you work multiple jobs and you are receiving, and you are able to telework for one of your jobs, but you have lost income because you aren't able to go work at another job, you can apply for unemployment for the income that you were losing for the job that you cannot go to. The amount of this is $600 plus half the average unemployment benefit of your state for 13 weeks. So again, Florida, they have the minimum of 32 and the maximum of 275, but I wasn't able to find information about what the average unemployment benefit is. So the amount that you would get under the Pandemic Unemployment Assistance Program if you don't otherwise qualify for Florida unemployment would be $600 plus some amount between $32 and $275. In order to apply, whether you qualify under Florida's system or whether you're applying under the expanded provisions of the CARE Act, you need to submit this information through the Florida website, which is called the Connect system. I recommend collecting all of this information prior to attempting to submit a claim. You'll need your social security number, your driver's license number or a state ID number, and then employment information for the last 18 months for each employer. The name, address, and phone number, first and last day of work, gross earnings, reason for separation, the employer federal employment identification number that can be found on your taxes, on the tax forms that they give you. And this is the website that you would apply at. Currently, the Florida Connect system is not set up to process claims for the Pandemic Unemployment Assistance Program, and the information on their website has not been updated in the application process. So if you're applying and you wouldn't otherwise qualify under Florida's system, you might be running into things on the application that you don't qualify, and just know that the application has not been updated to reflect these changes. The Florida Department of Economic Opportunity, which I'll call the DEO from now on, Department of Economic Opportunity, did issue a guidance yesterday advising that people apply through the Connect system to see if they qualify under Florida system, even if you know you won't, and that they will be evaluated under the Pandemic Unemployment Assistance Program. I know this, this probably won't work in all situations. For example, some people are ineligible for the Florida benefits if they have already exhausted unemployment benefits. And it does not appear at this time that there is a way to file an application through Connect if that applies to you. At this point, they appear to just be advising to use the current system, even though it's not really tailored to the situation. But hopefully they'll be able to make improvements soon. The Connect system is woefully inadequate to handle the volume of applications that it is currently receiving. Even before the situation that we are in, auditors had said that the system that Florida is using is not adequate. Governor DeSantis did announce a few days ago that he has hired an outside contractor, which will hopefully speed up the process and improve the site. But at the moment, the site is reported to be crashing constantly. Many people are not able to complete their applications and end up getting kicked back to the beginning and losing the information that they inputted. And the DEO is advising applicants to try to apply at off-peak times, like late at night or early in the morning. Finally, while normally it takes about 3 weeks to process an unemployment claim, you can expect claims to take much longer now due to the volume. So normally 3 weeks, so we're expecting at least 4 to 6 weeks to process these claims. As you can see, this chart shows the increase in claims over the month of March. And given the statewide stay-at-home order that was just issued, these numbers are only expected to grow. So at this point, regarding unemployment, I can really only advise persistence because these benefits are available to you. They have been passed and signed into law. And it's just a matter of waiting for the Florida system to be able to come into compliance and be able to deliver them to you. So if you have any questions about whether you qualify or if your reason for not working is a qualifying COVID-19 reason, please do let us know and we can help you evaluate your claim vis-a-vis both the Florida system and the Pandemic Unemployment Assistance Program. So that is the end of the information that I've prepared. There was one question, so I'm going to exit and I'm going to stop the screen share. Oh, I already stopped it. Okay, and look at the chat. Okay, so the question was about if you hadn't filed taxes yet for this year, the IRS will be looking at the information provided in 2018. I hope that answers. So if anyone, it is almost 4, so I understand if people need to get going on with their day, but I'm happy to stick around for minutes and answer other questions. Feel free to unmute yourself if you don't mind asking over so everyone can hear, or you can send a private chat as well if you'd rather not. All right, well, I hope that was helpful and informative for everyone. Again, if you have questions that are specific, or you'd like to speak with me specifically about something that you're facing or that I didn't address, my email address is legallink@locusprojects.org. You can email me and I'm happy to set up a time to speak. Additionally, like I said, I'll be putting together some information about the small business loans that are available to independent contractors and self-employed folks to help you determine what's available to you. I think there might have been another question that came in. I'm not sure I understand. Okay, if there's any other questions, just again, feel free to email me. Again, that's legallink@locusprojects.org. Or if there's any other topics that you think would be helpful to be covered, I'm happy to put another one of these together as well. I hope you all enjoy the rest of your days, stay safe and healthy, and let me know if there's anything that we can help out with. Bye.